I did prepare a one-page handout. Have most of you got that? Notice some people in the front row, they probably don't need it. They might be able to follow even without the handout. Well, my topic, as you know, is succession to the throne. And as you also know, this became a very popular topic when the Duke and Duchess of Cambridge, and I might say I call them Will and Kate, I'm on close terms with them, were expecting a baby. And that baby, which of course was born last July, I might say that my talk is an article which I have completed, submitted to publication in the National Journal of Constitutional Law, but it hasn't been published yet, but it will come out there eventually. So anybody who wants to see the full thing, and there are some footnotes in it which I'm really proud of. It's a topic you can get a little crazy with on footnotes, and I did. There's probably someone out there that likes reading footnotes, and for that person I say, yeah, have a look at it. Now, while we were waiting for this baby to be born, there was obviously a possibility that the baby would be a girl. And in fact, of course, the baby turned out to be a boy. And one thing that Kate said in a sort of indiscreet moment, which was reported in Hello, I gather, and I read Hello, but only in the barber's shop, so it's rather infrequent. But apparently she said in her Hello, that'll be, when she received the gift for the baby, she said, that'll be very nice for my and then stopped at And so everybody in Hello said, it's going to be a girl, because she didn't say that'll be very nice for my So anyway, it was the possibility that the baby might be a girl that was the impetus to change the rules of succession before the baby was born, so that it wouldn't, the new rule would be in place for whoever the baby was. And the reason for the concern is this, that the British monarchy goes by the rule of primogeniture. And primogeniture just means firstborn. So the firstborn child of whoever is the king or the queen becomes the new king or queen. But the common law of primogeniture, which is the law that deals with succession for the royal family, is male preference primogeniture. And the way male preference primogeniture works is that a firstborn son ranks ahead of even an older sister. It's a firstborn son. Now, it doesn't exclude women. The reason why Queen Elizabeth II is on the throne, and has been on the throne for about 60 years, as you know, she was the firstborn daughter of George VI, but she had no brothers. Had she had a brother, the brother would have succeeded on the death of King George VI. And in fact, we've had many great queens. In fact, those of you that have been reading Hilary Martell's books on the Tudors, or watching the TV series of the Tudors, and were learning all about Henry VIII's obsessive quest for a male heir, you were probably struck by the fact that there was no way Henry VIII could know that the daughter that he'd already had by Anne Boleyn, she was the second of his wives, whom he later beheaded, the daughter he had had by Anne Boleyn was actually going to be the greatest monarch that Britain ever had, because that was Queen Elizabeth I, and she reigned from 1558 to 1603. It was England's golden age. They defeated the Spanish Armada. They obtained supremacy over the world. They got many colonies. It was a fabulously prosperous time, presided over by a queen. So Henry should have stopped worrying about that and settled down with Anne Boleyn instead of beheading her and her 4 successors. He really was a bad guy. So although we've had some great queens, and we shouldn't forget Queen Victoria, of course, because she reigned for 64 years. Obviously, male preference primogeniture is discriminatory. And now was a good time to correct it, because the next 2 successors to the throne, the next 2 in the line of succession after Elizabeth, are Charles, firstborn boy, so he wouldn't be affected by changing the rule, and then William, firstborn boy, he wouldn't be affected by changing the rules. So if you did it now, before the baby was born, then even if the baby was a girl, it would be corrected in time for her. So what happened was this. In April 2013, and remember the child was born in July, George was born in July, so it's quite a while before the baby was due. What the Parliament of the United Kingdom did was they enacted a rule which replaced the rule of male preference primogeniture with a new rule of equal primogeniture. And the UK Act, which I think I've set it out in the, I've lost my place here, but I think I've set it out in the handout. Yeah, the succession to the Crown Act 2013, in determining succession to the Crown, the gender of a person does not give that person or that person's descendants precedence over any other person whenever born. So that changed the rule for the UK of primogeniture from male preference to equal primogeniture. My paper goes on to talk a little bit about another aspect of the Act, which I'll just tell you about very briefly. Another feature of the rules in place at the time of the change was that they were also discriminatory against Catholics. A person could not succeed to the throne who was a Catholic, and no monarch could marry a Catholic. So those were 2 other rules. There were some reasons for those rules at the time, but they are obviously ridiculous now. So just as an aside, what the UK Act did was it got rid of the rule against marrying a Catholic. So Prince George will now be free to marry a Catholic if he wants to. But it didn't change the rule that the monarch cannot be a Catholic. And that's because of the fact that England has an established church, the Church of England. The monarch is the head of the Church of England, and one of the old statutes, the Act of Settlement, provides that the monarch has to be in communion with the Church of England in order to fill that role. Now that could all have been changed too, but obviously the government of the UK didn't want to tackle the established church topic, and so left that one alone. But of course it does mean, and there was a case in Ontario challenging it, it does mean that the King or Queen of Canada also can't be a Catholic. And that was challenged in an Ontario case, and I'm not going to go into that case because it's a bit too much of a distraction. But the court eventually said that it couldn't be challenged even under the Charter of Rights. Now, what I want to talk about is how does this all get translated into Canadian law? What does Canada need to do to keep its law of succession consistent with the UK? Now, note first of all that ever since the patriation of 1982, the UK Parliament has had no power to legislate for Canada. Not even with the request and consent of Canada, which did used to be possible before 1982. Not even with request can the UK legislate for Canada. And so the UK Act doesn't directly apply to Canada. And when you look at our constitutional instruments, the unanimity procedure of Section 41, recently applied in the Nadon case, the unanimity procedure of Section 41 has a list of items which require the unanimous support of all legislatures and the Parliament of Canada. And one of the items on it, 41A, is the office of the Queen. So, does that mean that a change in the rules of succession for Canada would require a constitutional amendment under the unanimity procedure in order to fall in line with the change already enacted in the UK? You can imagine what a bad result that would be. Now, what the Government of Canada actually did, and I've set this out in the little handout, Parliament passed the Succession to the Throne Act 2013, And the full text I've set out there, the alteration in the law touching the succession to the throne set out in the UK Act of 2013 is assented to. That's it. Unilateral action by just the Parliament of Canada, no amending procedure, doesn't even say that the rules of succession in Canada are changed. It just says that the alteration of the law in the UK Act is assented to. Is that enough? As you probably know, there is litigation bumbling around somewhere in the province of Quebec, because the province of Quebec takes the position that no change to the succession of the throne should be able to take place without the approval of the National Assembly of Quebec. And so ultimately that case is going to have to resolve the question of, does it need a constitutional amendment under the unanimity formula? My argument is that the government got it right, that it doesn't need a constitutional amendment, and that simply assenting to the UK Act is all that Canada needs to do. Let me walk you through that argument. First of all, we have to start with the meaning of the Queen in the Constitution of Canada. And it's a little bit troublesome that the Constitution Act 1867, which makes numerous references to the Queen is the head of the executive government of Canada, and the Queen is a party to the federal Parliament, along with the House of Commons and the Senate. And although the Queen has in fact delegated all her powers to the Governor-General, nevertheless, she has an important place in our constitutional instruments. But she's not defined in the Constitution Act 1867. And in the Constitution Act 1982, which, as I say, says that the office of the Queen requires unanimity for its amendment, there's no definition there of what is meant by the Queen. I think the answer to that is to go to the preamble of the Constitution Act 1867. And one of the preambles in the Constitution Act 1867, the old BNA Act, recites that the provinces, and I put this into the little handout too, the uniting provinces have expressed their desire to be federally united under the Crown of the United Kingdom. That's the preamble. It's not an enacting provision, it's just a preamble. But I think it's reasonable to infer that in the absence of any express provision to the contrary, that must articulate the meaning of the Queen where those words appear elsewhere in the Act. In other words, it's the person who holds the crown of the United Kingdom. And there are other reasons for believing that to be true, because the other Commonwealth realms, those members of the Commonwealth that recognize the Queen, not all of them do, but they all have to have the same Queen. So it's important for there to be symmetry among the Commonwealth realms, and that symmetry is provided if each accepts the same person as is the person who holds the throne of the United Kingdom. So I say that Canada doesn't actually have any rules of succession. What Canada has is a rule of recognition. Canada automatically takes as its monarch whoever is the monarch of the United Kingdom. Now, if you're with me so far, if that's right, then any changes to the line of succession of the monarchy in the United Kingdom will be effective to change succession to the Queen of Canada as well. That's not because the UK law applies to Canada. It does not. It's because Canada identifies its sovereign by reference to the external fact of whoever is sovereign of the United Kingdom. And that person is identified by the rules of succession of the UK. All right, well, if you're with me so far, you may ask the question, well, why does the Parliament of Canada have to do anything then when the UK makes a change to the rules of succession? If that's going to automatically change the rule for Canada as well, why does Parliament have to act at all? And the answer to that is that Parliament doesn't have to do anything at all as a matter of strict law. But in the Statute of Westminster, 1931, which was a very important statute in the constitutional history of Canada and the other Commonwealth countries, the Statute of Westminster wanted, as far as possible, to make the so-called dominions, which Canada was the senior example, as equal as possible with the United Kingdom. And the preamble of the Statute of Westminster stipulated, and I've got that set out in the handout as well, that any alteration of the law touching the succession to the throne shall hereafter require the assent as well of the parliaments of all the dominions as of the Parliament of the UK. So the idea was that the UK would not, in fact, make changes to the succession to the throne without the assent of the various Commonwealth realms, the Commonwealth countries that also recognised the same Queen. And so what happened was, before the UK Act was passed, in October 2011, the Prime Minister of the UK met with the Prime Ministers of all of the Commonwealth realms. I think there are 16 of them. It's more than you think, because a lot of small places. It's not just Canada, Australia, and New Zealand. He met with the Prime Ministers and he told them what he wanted to do, and he asked for their agreement. And I think they all said, oh yes, certainly. But he also set up a process under which each one of the Commonwealth realms, including Canada, assented in writing to the changes that he was proposing. So what Canada was doing in the Act of 2013 was simply doing what was requested. It's only a convention, really, because it's in the preamble of the Statute of Westminster. It's not enacted by the Statute of Westminster. It was simply giving effect to this convention that Canada would assent to whatever changes to the rules of succession were made in the UK by an Act of Parliament. And that's what it does. So all Canada is doing in passing that Act is simply confirming that after the changes, Canada is content to continue the existing constitutional position that its monarch be the same person as the monarch of the United Kingdom. Canada's rule of recognition is not changed. The symmetry of all realms having the same queen is not changed. There's no change to the Constitution of Canada because the meaning of the Queen is simply that rule of recognition that I stated, and no amendment to the Constitution is needed. So I think that the simple enactment of the 2013 statute by Parliament is all that Canada needed to do to preserve the symmetry of a UK monarch. For Canada and the other realms have done the same thing. Well, some of them have done different things, but that's all that needs to be done in Canada. So to go back to this litigation in Quebec, which I have not particularly been following, I don't know how it has progressed, but to say that any changes in the rules of succession require an amendment to the Constitution of Canada, which presumably would be under the unanimity procedure, that doesn't stand up to analysis if one accepts the premise that references to the Queen in the Constitution Act 1982 and in the Constitution Act 1867 are references to the person holding the office of Queen. She's Queen of Canada now, but it's the person holding the office of Queen of the United Kingdom who is the Queen of Canada. So that when the UK alters its rules of succession, it doesn't change the definition of the Queen for Canadian purposes. The same rule of succession will always yield exactly the same person as the rules of succession will, even after alteration, will still yield the same person for Canada as for the UK. Now, it may be that one day Canada might want to depart from the UK rules of succession. Doesn't seem very likely, and have our own king or queen. What is more likely is that Canada might decide to become a republic and not have a king or queen at all. And now, if that were to happen, then that would entail an amendment to the Constitution of Canada, because you'd be either changing the definition of the Queen by getting out of symmetry with the UK, or you'd be abolishing the Queen entirely and replacing her with a president. So if that were to happen, then of course there would be a change to the Constitution of Canada. Section 41A would be engaged, and it would require an amendment under the unanimity procedure. Now that seems perfectly sensible for a change that would be as radical as that. But it would be completely inappropriate if the same rule of unanimity had to be applied to changes in the UK rules of succession to which the Parliament of Canada was willing to assent. So, my conclusion then is we don't need to worry about the amending procedures. As long as Canada does not want to strike out on its own and abandon the symmetry with the UK, no amendment of the Constitution of Canada is required. None of the amending procedures is applicable. What is applicable is the preamble to the Statute of Westminster, which declares the existence of a convention that requires only the assent of the Parliament of Canada. And that assent was provided by Canada's enactment of the Succession to the Throne Act 2013. That's the end of the argument.